There have been mixed views about the announcement by Minister of Legal and Constitutional Affairs Marlene Malahoo Ford that the new Bail Act is coming. While it hasn't been tabled, some members of the legal fraternity and human rights groups are expressing concern. To tell us why, I'm joined by legal correspondent Dion Jackson Miller. Thank you so much for joining us, Dion. Why the fuss? Why have there been such negative reactions to this announcement?
In a nutshell, Janella, there are concerns that the government could be attempting to further restrict the granting of bail and to do so in a way the concerns are that could be unconstitutional. So for that, for instance, you need to look at what's the purpose of bail, and perhaps you could bring up our first slide there, because you hear a lot of the discussions that seem to suggest that the person has been convicted already and we're sending them to jail. The point at which you're applying for bail is the point at which you've been charged and you're before the court. So bail, the courts have said, is not, denial of bail is not to be used as punishment. The point of bail is so that you come back to court to answer to the charges against you. And then you have to look at our constitutional provisions, and if we could bring that up as well, because we have a number of constitutional provisions that are relevant here. So you have the right to liberty. We have a constitutional right to liberty, and of course that can be curtailed in some circumstances, such as if somebody is before the court. We also have an entitlement to bail. So we have a constitutional entitlement to bail, and that's really important here. And of course, you have the very important presumption of innocence. So we can't say, let's lock up everybody once they've been charged, because the person has not yet been found guilty. You're presumed innocent until you're found to be guilty.
All right, so Dion, now can the government abolish bail for people accused of serious crimes if they want to?
Well, again, you come back to the constitutional issue, because remember, the Constitution is our supreme law. So any law that has been passed, that is being passed, has to be in accordance with the Constitution, or it can be struck down, as we saw with NIDS. And the important thing I think people forget is that we already have a Bail Act that sets out a very comprehensive regime for the granting and the denial of bail. So if we look at what we have up on the screen there, the Bail Act tells us how bail can be denied if there are grounds for believing that the person would fail to surrender to custody, commit an offense while on bail, interfere with witnesses, or if the person was on bail already and then committed another offense. There are other factors that have to be taken into account as well, and let's bring those up. So the courts, for instance, have to take into account the nature and seriousness of the offense. So if the person is charged with murder or charged with a gun crime, the court already has to look at that in deciding whether to grant bail, look at the person's character, in antecedents, meaning any previous convictions, their record, did they previously have bail granted, and if so, how did they act while they were on bail, how strong is the evidence against them, and if the person is a repeat offender. So all these things are already in place. So the question is, what else is the government going to be seeking to do, and what are they going to be trying to put in place?
All right, already in place, but what have the courts said about bail in the past?
Well, there was a case in 2010 concerned about crime, and the government brought into law 6 bills that we call the anti-crime bills. And 2 of those bills dealt with amendments to bail. And part of what they did was to shut out bail for people charged with very serious crimes for a certain period of time. Now, there were 2 people, one of them Adrian Nation, so the case we generally refer to it as Nation, challenged the law as being unconstitutional, and the court agreed. The court struck it down, those provisions that restricted bail, saying that this is something for the court. It is a court who is supposed to decide whether somebody gets bail or not the executive. That it insulted or infringed, perhaps I should say, the presumption of innocence. That was a big issue as well. And the concern then is, having gone through Nation, what is the government going to come to? I should say that I did speak this afternoon with the Minister of Legal Affairs, and she did say she's seeking to amplify and clarify some of the existing provisions of the law, including, she said, the fact that there will be included a provision for people on bail to wear electronic monitoring bracelets.
All right, thank you so much, Dion. Of course, that bill will be tabled very soon. Now, still to come this evening,